Hello and welcome everyone to Amigos IAS. I am ADNAN. Last week on August 3, the government has introduced Digital Data Protection Bill in the Parliament, and today it is expected to come up for discussion. So in this backdrop, let us try to understand what this bill is, what are the highlights of this bill, and what are the concerns and issues with this bill. So let me start with the purpose or the aim of this particular bill. It is to provide the framework to process digital personal data of individuals in a lawful and transparent manner, while also understanding the importance of the privacy or the rights of individuals to protect their data. So I'll just break it down into simple points. First thing, of course, we have to collect the data of the individuals. We need to collect the data, sometimes process the data, store and use it for different purposes. We have to balance that along with the concerns of the individual right to privacy as well. So two components are involved in this particular bill. And if we see some important terms, before that, let us go for the background or the evolution of this particular bill, because this has been under discussion for at least around 6 years, and we don't have any comprehensive data protection law in India so far. We usually use the framework of IT Act 2000 so far. We want to have a comprehensive data privacy law. If we talk about the international examples, the European Union's GDPR, General Data Protection Regulation, is the most comprehensive data privacy law we have seen in the world. That is a very typical or a standard example for many countries wanting to pass a data protection law. So India, let us try to see what is the background behind this particular data protection bill, starting with 2017. Okay, almost 6 years ago, under the guidance of MeitY, Ministry of Electronics and IT, government will frame a committee here on the names of, government will try to frame a committee here headed by Justice B.N. Sri Krishna to examine issues regarding data protection in the country. Then that committee will be giving its report in 2018 July. Based on the committee recommendations, government will table a bill and introduce in Lok Sabha in December 2019. And after that, the bill is referred to a JPC, Joint Parliamentary Committee. Joint Parliamentary Committee will give the report in 2021, and 2022 August the bill was withdrawn from Parliament because of various concerns by various quarters of people. Fine. And in November 2022 last year, a draft bill was released for public consultation. And now this year, public consultation was not given for the current draft, and in August 2023, that means last week, the Digital Personal Data Protection Bill was introduced in the Parliament. That means, for the exam perspective, for your mains, you don't have to write the entire timeline here, but you should just be knowing what happened in the last 6 years with respect to this particular bill. And now, if we see some important terms before we go ahead, what is the meaning of personal data? I will be highlighting some of the key points here. You should pay attention. We are not talking about any public data which is readily be available or accessible in the public domain. We're talking about the personal data of individuals like you and me. That is under concern here. And information or data that relates to an identified or identifiable individual, that is called as personal data. Whatever information data we have, our name, our contact number, our address, all these come under personal data. What is processing? That means there is a data collector who collects your data, and then the data can be used for other purposes, to make some kind of algorithms, to make some kind of, to store the information, to use the information for analytics as well. So you can see here, what you can do here is collection, storage, use and sharing. That is what happens in data processing, because they have a purpose for using your data, right? And now let us see some of the important highlights of this bill. The bill will apply to processing of data within India, where data is stored and collected, and sometimes outside India also. If any company or if any entity outside India is providing goods and services to us, then they can collect our data as well. That means both within India and outside India also, this personal data is considered in this particular bill. And this will be processed only for a lawful purpose upon consent of an individual. That means you are consenting that your data can be used for certain purposes. Sometimes consent is not required for specified legitimate uses. Sometimes you may voluntarily share your data with some entities. Sometimes the government may take for various purposes, for the welfare schemes, for any licenses, for any permits, for any government benefits which it provides. Government can take your data without your consent as well. So hold on, we will discuss the issues later. Data fiduciaries will be obligated to maintain the accuracy of data. This bill talks about the rights and duties of data fiduciaries as well as data principals. I'll just come back to that. Data fiduciaries here means the entities which collect our data. For example, Google, Amazon, they take our data. Whenever you have a Google account, Google will take your information. Google will see if you're logged in, where you are going, what time you are spending at what place. All the data is collected by this fiduciary, that is called as data fiduciary. Google and Amazon are the examples here. They should maintain the accuracy of data, keep the data secure and make sure that it is quite secure and no breach will happen, because once you breach the data, your data is breached by the hackers, the data will be released for everyone in the public domain. And delete data once its purpose has been met. That means this bill talks about the minimization of data collection. Exactly for what purpose you want data, collect only for that purpose, and if the purpose has been met, then you have to erase the data. That is what the data fiduciaries will have to do here. And the bill also grants rights to individuals. We call them as data principal. Data principal are we who actually subscribe to these platforms. We give our data for them. So what are our rights here? Right to obtain information, like why you can ask Google, why do you want to take this information from me? Why do you seek the information from me? You can ask them and seek correction and erasure. For example, sometimes your wrong information is there, or sometimes you feel that your purpose has been solved, your account should be deleted from that particular fiduciary. You can ask for that as well. That is your right. And grievance redressal. What if some data fiduciary is not complying to your request? You have the option to ask them, to lodge a complaint with them that you have certain grievance and you want it to be redressed as soon as possible. What if they don't respond? I'll come back to that. Central government may exempt government agencies from the application of provisions of the bill because of security of state, public order and prevention of offences. These are the grounds on which the central government will be empowered to not apply the provisions of this bill and collect your data. See, very concerning point here is because the maximum data repository, the collection is actually there with the government. And if the government says by notification that certain agencies of the government, certain agencies of the state and also private institutions also, if government gives a notification, then government will not be applying the provisions of this bill for those agencies. So a big threat of the data here it's happening. Fine. For security of state, public order and for preventing the offences, the central government can exempt some agencies. Fine. Central government will establish the Data Protection Board of India. Now, this is an ombudsman. This is a particular organization which will be enforcing the provisions of this bill, compliance of this bill, and penalties also will be given if anyone is not complying, whether it is we the individuals, the data principals, or the companies like Amazon or Google who are the data fiduciaries. They also have to comply with this particular law. Otherwise, punishments will be given. For example, if we also do not give right information, if we impersonate someone, like we make fake accounts of some people also, we try to be someone who we are not, and sometimes we may give fake complaints, wrong complaints also, this is punishable by at least 10,000 rupees. What about the data fiduciaries? They have to inform the user in case of any breach of data happens. They should make sure that there is no breach of privacy of the user, and if they don't follow it, if they, for example, release any information of any children, then penalty of more than 200 crores will be applied against them. Or if they are not able to safeguard the data of the people, then also around 250 crore rupees penalty will be imposed on the data fiduciaries. These are the important duties of the data fiduciaries and data principals as well. So I hope you are able to follow. In case you haven't followed, please pause the video, listen to my point again, or you can also comment in the comment box. I will be happy to reply to you. Fine. That means we are understanding the relationship between the government, data fiduciary as well as data principal. What are their rights and responsibilities have been mentioned in this act. Exemption is being given to the central government for some purposes like security of the state, public order and Also for the prevention of offenses, government can take your data, fine, and this data protection board will be able to ensure compliance of this particular act. Then what are the issues and analysis? We will be discussing a few points here. Exemptions to data processing by the state on grounds like national security will lead to data collection, processing and retention beyond what is necessary. This may violate the right to privacy. That means in Puttaswamy case, we have to understand an important point here. In Puttaswamy case, Supreme Court has held that right to privacy is a part of Article 21. It is granted to everyone, all the citizens. Definitely it is available for all of us. But the point is, government can sometimes collect our data for the national security purposes beyond what is necessary. That means the government is not liable to erase your data once the purpose has been met. And sometimes by saying that public interest is involved, government can keep your data indefinitely. That is one aspect which is not good in this particular bill, because government holds a lot of individual data and the government can use the data multiple times for various purposes. So storage limitation, that means you are not able to provide some limitation on how much time you can use the data as for the central government goes here, fine, and state itself. The bill does not regulate risks of harms arising from processing of personal data. What if your data is breached? Of course, generally the company which has not able to save your data should be paying some kind of amount for us, compensation. That is also not discussed here. And what are the risks of harms? What if somebody misuses your data? Bill is not quite clear on how to safeguard that, how to redress that. Next one, it does not grant the right of data portability and the right to be forgotten to the data principal. That means we. For example, I am having an account on Google, I am having an account on Facebook. I want to transfer all my data on Facebook to other social media website. That means my data should be portable from one social media platform to other platform. Of course, Facebook need not tell all the trade secrets what they have regarding me, but at least my data which is there with Facebook should be portable to other social media platform, for example like Twitter. Data portability has to be there. I will have control over my data, but that is not addressed in the current bill. That is the issue here. Next point is what? Right to be forgotten. Right to be forgotten is one of the important principles. See, GDPR of Europe, European privacy law has 8 important principles, out of which these 2 are also important principles. They have in European Union, right? Data portability is there. Right to be forgotten means what? Sometimes you don't want yourself to be located on the internet and you will be telling this data fiduciaries, please erase entire data of mine. I don't want to be searched or accessed on the internet if somebody searches my name. That is called as right to be forgotten. You should not be seen on the internet. That is what is the meaning of this. This also has not been addressed in the current bill. And the bill allows for transfer of data outside India. Central government will give notification like from which countries we can send this data. But the problem is, if our data is sent to some other country, if that country does not have proper data privacy law, our data can be misused in that country, yes or no? That is the point here, fine. So it may not have adequate evaluation of data protection standards where we transfer our data. For example, from country India, if I transfer my data to some other country, what if that country does not have strict data privacy law? That means my data will be sent to the data brokers and they will sell away my data to everyone in the internet. That is very dangerous. It has also not been addressed in this particular bill. Then the members of Data Protection Board, because I told you there is an ombudsman called as Data Protection Board of India. This will be responsible for the enforcement of this particular bill or the act. This board will have members, their tenure, the chairpersons, everything decided by the executive, which is the central government here. That means more power is there in the hands of the executive to appoint members of this. That means the autonomy of this particular data protection board is not guaranteed because it is in the hands of the executive and the term of the members is only how many years? 2 years, and they are eligible for reappointment. That means again autonomy will be affected here, hardly 2 years. In other cases, if you see, Competition Commission of India chairperson has 5-year tenure, SEBI chief has 5-year tenure. If you give short tenure of 2 years, it is not going to give the kind of freedom for the person to take his own decisions, and they are eligible for reappointment means they can be leaved again and again to bend to the government rules as well. That means autonomy is not there for this newly about to be constituted Data Protection Board of India, and their functioning can be impacted. Not what only that, last 2 points here. As per the IT Act, which usually governs the data protection in India as of now, it imposes a duty on the corporates. If your data is misused, provide damages to you. That is the point here. If you don't handle data in a proper way, if you are negligent. But the current bill, Data Protection Bill, clause 44 clause 2, aims to exclude the application of section 43A. 43A says provide damages in case you are negligent with the data of a person. But the current bill says no need to pay for that amount if any kind of data privacy happens. But of course, independently, the government overall can impose penalty of at least 250 crores for any non-compliance with the bill. But here the individual cannot be asked to give damages or compensation by the companies. That is one another provision here. And what about the RTI Act, Right to Information Act says we as citizens of India have Article 19 clause 1 subclause A, right to freedom of speech and expression, which also includes right to know. So if I know something, then I can express something. So right to information has been held as a part of fundamental rights, Article 19. That means I should know who are the willful defaulters in India. I should be knowing what is the kind of NPS in India. Information I need. That information is very sensitive, but I need that because informed citizens will play a very important role in democracy, and it is a part of my fundamental right. But current Act actually exempts this. As per section 8 clause 1 subclause J of RTI Act 2005, it prohibits sharing of personal information which has no relation to what here? Public authority. In the interest of public activity, you need not share certain information, but it allows the release of information if the public authority is satisfied that the larger public interest justifies the disclosure of information. That means if I have to share the list of all the defaulters in India, it is a larger public interest. It is my right to know. But the current bill has a provision which negates this. That means it is going against this section 8 clause 1 subclause J, which actually allowed some information to be disclosed for public interest. Now that may not be disclosed even if public interest is involved. So these are some of the troublesome provisions of the bill. And because the bill is yet to be passed by the parliament since I am recording this video, so once the bill is passed, and if these concerns are addressed, I will just come back to this topic again and I will make a short video. So if you have any questions, please post in the comment box. I will be happy to clarify. I will see you again in the next video. Until then, thank you. See you.